now to join two of the we're pleased now to join two of the fine states attorneys in our state that are heavily involved in the discussion about the Safety Act and cash bail, pretrial fairness act, however exactly define. Well, hey there. Live from my basement here on a Wednesday. It's the Illinoize Livestream podcast. I'm Patrick Pfingsten. I write the Illinoize.com, where we write a political newsletter and have a website and do fun things like this live streaming newsletter. So our live streaming podcast. So thanks so much for being with us. It's the first week of veto session in Springfield. Very little happening this week in terms of what's going down at the Capitol and especially in the realm of the Pretrial Fairness Act, or the Safety Act, as it's often known, in terms of ending cash bail, reforming that system in the state. And we'll have, that's kind of the focus of our conversation today. We'll talk to two of the state's attorneys that are closely aligned with the discussions and potential changes. DuPage County State's Attorney Bob Berlin and Champaign County State's Attorney Julia Rietz. They'll both join us on the show today. The big news out of this week in the General Assembly is the election of two new Republican leaders. House Republican leader Jim Durkin announced the day after the election that he would not seek another term as leader. There was kind of a mad scramble afterward, but Representative Tony McCombie from Savannah, up in the northwest corner of the state, was the choice of Republicans to become the new House Republican leader. She becomes the first non-Chicago media market Republican leader since, as far as I can tell, the early 60s. George Ryan, I guess, is technically downstate, since he's from Kankakee. He was there in the early 80s, though he's in the Chicago media market. So whether you call that downstate or not, we'll let you decide that. But McCombie is from Carroll County, up in the far northwest portion of the state. Generally regarded as an incredibly hardworking, likable representative. Somebody I've gotten to know and think highly of, and we'll be interested to see how things shake out for her after House Republicans essentially got drubbed on election day. And she's got a lot of work to do to recruit better candidates, to raise some money, which the Durkin regime did a pretty poor job of. And in the Senate, Senate Republican leader Dan McConkey was deposed after the best result for Republicans in the Senate on election day in years. They raised millions of dollars, which they hadn't done in decades. They won 2 seats, had a net gain of 1 because Democrats picked up a new seat in the Quad Cities area. So they netted 1 seat, which Republicans haven't done since 2014. But yet McConkey will be replaced by John Curran, the more moderate senator from Downers Grove, former University of Illinois football player. And we'll see what kind of direction he brings to the caucus, what kind of changes he makes, and maybe if you'll see a more moderate focused GOP in the Senate trying to make themselves relevant, because obviously with 20 members, it's hard to be relevant in the Senate. So we'll keep an eye on those things, but 2 new Republican leaders as we head into the new General Assembly in January. Let's turn our attention though to the hot button issue of veto session, which isn't really happening much this week, but I think will be on everybody's minds when the legislature returns to town in like 2 weeks. We're pleased now to join 2 of the fine state's attorneys in our state that are heavily involved in the discussion about the Safety Act and cash bail, Pretrial Fairness Act, however exactly you want to define it. DuPage County State's Attorney Bob Berlin and Julia Rietz, the Champaign County State's Attorney. Bob's a Republican, Julia is a Democrat. Full disclosure, I worked on Julia's campaign in 2016 and have known her for many, many, many years, dating back to when I was a reporter. So that said, Julia is also the president of the State's Attorneys Association in Illinois. So she's been involved in the negotiations that have been taking place on what sort of legislative action will be taken on the Pretrial Fairness Act and the cash bail part of the Safety Act. So, Bob, I want to start with you, if you don't mind, since you were included in a lot of the political angles that were used over the last few months that really tried to make this law look as if it's essentially the end of the world, and we're going to do mass release of criminals. What's the truth behind this? I mean, what is your main concern as we approach January 1st on this law?
So look, it's never been about politics for me or any of the state's attorneys. It's really about public safety. And I realize it became a political issue. It was used in the campaign, but that was never my intention. And I don't think it was the intention of any of the state's attorneys in the state. We're concerned about public safety, which is why you see state's attorneys on both sides of the aisle working together. The biggest concern that I have and that we all have is that the Safety Act removes discretion from judges in making a determination of who should be in custody or out of custody pending trial. It takes away their ability in many cases to detain people if they're a danger to the community. And for categories of crime, not all crimes, but many categories of crime, the only way for a judge to detain someone is if they find they're a willful flight risk, which is a difficult standard to prove. And it removes their ability to detain people if they're a threat to a person or the community or likely to obstruct justice or intimidate witnesses. That's our biggest concern, is that when you take that ability away, we are going to see more dangerous defendants out on the street, and it's going to have a big impact on public safety.
Julia, there was a lot of pushback from Democrats, specifically the governor, on the idea of non-detainable offenses, which I think might be a misnomer because it isn't necessarily listed that way in the law. As you read the law, and again, you're a Democrat, the governor's a Democrat, so it's not a partisan thing here. As you read the law, what's your thought? What's your concern on the idea of what crimes or alleged crimes can and can't be considered for detainment?
Well, I think Bob is exactly right that the issue here is, the issue is nobody is lying, or but maybe we're all kind of using our lawyer voices to put things into a perspective that fits our narrative. So you're right. There isn't anything in the statute that says non-detainable, but Bob is right when he says that there are certain offenses that can only be detainable if the court makes a specific finding about willful flight. And the definition of willful flight is very narrow and basically requires us to be able to show that somebody has a bus ticket to Georgia, or that sort of thing. It's a very specific and extreme definition. So I can give you some examples of offenses that would fall in that category that would only be detainable if there was this willful flight risk. Driving under the influence of alcohol. Someone with multiple DUIs is not detainable unless we can show this willful flight risk. Intimidation, threatening a public official is not detainable unless we can show this willful flight risk. So if somebody calls up and threatens me, Bob,
the guy that threatened Darren Bailey in the weeks leading up to the election.
Exactly. That is not detainable unless we can show that that person is a willful flight risk. And so I think that our concerns, just like Bob said, are about public safety. And we understand that there's no black and white in these situations. There's a whole lot of grays in every case. And we want judges to be able to look at each case on its merits, on its facts, on its history, and make decisions in that individual basis. That's why they're judges. I mean, that's why they get elected. That's why they get chosen, to use their judgment in making these big decisions. And they shouldn't be hampered by a list of of offenses that the legislature has chosen that prevents them from being able to address these bigger public safety issues.
Bob, in the end, is that what this comes down to? Is judges need more more flexibility under the way the law is written?
That's what we're asking for. That's what they have in New Jersey. The judge is really in the best position to make that decision. They hear the facts of the case. They're going to hear about a person's background, anything in aggravation, any reason why he should be detained. And then they're going to hear from a defense attorney as to reasons why the defendant is not a risk, why they can be released or released with conditions. And the judge should be the person that makes that determination, not the General Assembly. It's hard to put crime into a specific category. You could have a relatively minor criminal damage to property offense where 99 out of 100 times, everyone's going to agree this person's not a risk, they should be released. But what if the 1 out of 100 cases, the police find a list of people that the person wants to kill? Now maybe this person is a risk to the community, and our point is a judge should have the ability in that situation to detain that person pre-trial.
Julia, I can, and I'm trying not to make this a partisan thing, but obviously, there are Democrats out there who are defending what's in the law and essentially saying that, ending cash bail ends the idea that anyone can buy their way out of jail, which can or can't be the case depending on the standards that some judges use for setting bail. But is the end of cash, and Bob, I'll ask you too, since you're on the other side of the political aisle here, but Julia first, if you will, is ending cash bail, if everything along the lines that you guys are talking about, giving judges more discretion to say, hey, you're a bad dude, you need to be held pending trial, is ending cash bail that really that big of a deal in the end?
Well, so it's not just about the ending cash bail part of things. There's also a whole lot of other things that have been put into this new law that logistically are very difficult, not just for prosecutors, but also for defense attorneys. One of the biggest points of this whole new law is that it creates an entirely new and different process that's much more significant on the front end. So defense attorneys are going to have to do a lot more as far as communicating with their clients, receiving and reviewing reports, and there's just a lot more on the front end that is causing a lot of concern from them as well. The cash bail part of it, in some ways, that's actually good for us. There are certainly people, dangerous people who come in, we charge them with serious offenses, a judge sets a high bond, and somehow or another, they manage to come up with a large amount of cash and bond themselves out, or their families do. Or even there are agencies, there are organizations across the state, bailout organizations who post money for people to get them released. So those people, under this new system, if a judge finds them to be appropriate for a detention, they're not going to have the ability to bond themselves out. And in some senses, we may end up having the same number or even more people being held pre-trial. One of the offenses that is detainable is domestic battery, misdemeanor domestic battery. We may have people being held on misdemeanor domestic batteries that previously would have been able to post money and be released. So it's not the money part, really. It's the entire process part. And what is frustrating, I think, for us is that we were not involved at the beginning. And now, as January 1st comes upon us, there's all these commissions, Supreme Court commissions. We're on, I don't know how many commissions I'm on, Bob. I don't know if you know how many you're on. It seems like we're always on a Zoom call and always discussing something about how is this going to work? How is that going to work? And across the state of Illinois, everyone's trying to figure that out. From large counties like DuPage down to single state's attorney, one-man offices like Ford County near me. We're all trying to figure out how to make this work. And I think that is probably the biggest frustration, more so than the cash bail, not cash bail part, is the logistics.
Same question to you, Bob. Is ending cash bail really in the end that big of a deal?
As long as we have a strong preventive detention statute, the answer is no, it's not a big deal. The State's Attorneys Association for the past 2 years has consistently held the position that in theory, we were never opposed to eliminating cash bail as long as there was a strong preventive detention statute that gave judges discretion to detain the right people, to protect the community. And as Julia pointed out, we've had cases here where judges set bond at $2 million or $3 million with the understanding there's no way this defendant is going to post, and they do post, and they get out. And nobody wants that. With a strong preventive detention statute where you have no bond in these cases, they can't get out. So in theory, eliminating cash bail really isn't such a huge shock to the system as long as you have that strong statute. I will say this, for many counties in this state, there's a huge financial hit from eliminating cash bail because that money has funded parts of their criminal justice system, and there's no replacement. There was no funding replacement for that money in the Safety Act. And one of the biggest issues is a lot of that money gets used to reimburse victims in restitution. And without that money, there's no question that victims are going to see less of it coming in, and it does have a big impact on the system.
Julia, I know you've been, both of you have been involved in the discussions with the House working group on this issue. There's no action this week in the legislature, but when they come back in 2 weeks after Thanksgiving, there's an assumption that there's going to be at least some sort of a vote on some sort of a bill that's going to amend this law. Where do those negotiations stand at this point? I know that you're not going to violate any internal conversations, but just as you can explain it now, where do things stand?
Well, at this point, we're waiting too. We have met, I don't know how many hours, at least 2 to 3 times a week, 2, sometimes more hours a day, going through the act. And we have been following Senator Bennett's bill, which we support. And so we'll take some provision in Senator Bennett's bill and compare it to a provision provided by the advocates and discuss whether we can come to an agreement on that particular issue. And there are some issues that the advocates, the proponents of the Safety Act, have agreed need to be fixed. And they are willing to agree with us on those situations. There are other bigger picture issues like the detention net, like the detainable offenses that we're not going to agree on. And what I understand is happening at this point is that the legislators now have to look at, the legislators basically listen to us, go back and forth with the advocates, and they're going to have to decide where they fall and what they're going to put forward. We're hopeful that we'll be involved in that process and that we'll, receive what they plan on putting forward and can, give our opinion on that.
But are the progressives who are really pushing this, are they going to get behind any legislation that makes it easier to detain someone who's charged with a crime?
I don't know. And that's really the biggest problem. I do know that there are Democrat elected officials who understand that this is their one chance to make this work. And if it doesn't work, that in 2024, that's going to be hung around all of our shoulders, right? And so they understand, and also just they want this to work. They want their public safety to be, the issue that is of biggest concern. They want to make this work as far as the goals of the no cash bail and the goals of protecting public safety. The question is whether we can come to an agreement, and whether and always, how you count the votes, right? I mean, can we get Republicans, if we get something that we want, that we're comfortable with, we state's attorneys, can Republicans come to the table? Is everybody going to be so politically idealistic that they're going to dig their heels in? Those are all the questions that we don't have the answers to now. And I guess we're going to have to wait and see next week what language comes out, and frankly, whether we get behind it or not. That's a big question.
But Bob, essentially, you're the only Republican in the room. Republican legislators haven't been involved in any of these discussions, and Representative Windhorst, who I've talked to before, is former state's attorney who I've talked to about this, has opened the door to Republicans being willing to vote to end cash bail, but that the Republicans seem to be completely pushed out of these discussions. Are from someone who is on the different political spectrum of the guys who are running the show here. What's your takeaway on these discussions as you see the majority party trying to handle this is probably a generalization, the law and order type Democrat of a Scott Bennett, who's a former prosecutor, and maybe the more progressive, anti lock him up and throw away the key crowd in the Democratic Party? What's your takeaway as you've seen these negotiations unfold?
So, obviously Julia and I, we didn't have any control over who was going to be part of these discussions and these negotiations. We were invited, and we have taken part for the past 7 or 8 weeks in these discussions. It's hard to know why Republicans weren't invited, at least one, to be part of these discussions. I'm not going to begin to speculate why that's the case. I do know that the Safety Act obviously was passed on partisan lines, but it's my hope that when we're talking about public safety, this is an issue that Republicans and Democrats have come together on before, and can come together on if we get the right language. It's my hope that if we get what we're asking for, we can get legislators from both sides to support it. As you know, when both sides support a bill and you actually get a bipartisan vote, that's good for the public. I think the public gets behind it.
Would you whip votes if it were a bill you liked?
If it was a bill that, yes, if it had the language, what we're asking for, I would do everything I can to get Republicans to support it. But it has to have what we're asking for.
Can I talk about crime in general? I think, most of the people who watch this and read the newsletter know that I'm a downstater originally, lived in Champaign County for many years, and live in the Chicago suburbs now, in Cook County suburbs, just maybe 3 or 4 miles as the crow flies from DuPage County. But I think a lot of the issue with the Cook County crime problem, it's clearly a problem. I don't think that's me out on a limb here, but there's a huge problem in my view of whether the Cook County State's Attorney's Office is prosecuting people who are habitual criminals, who have been accused of multiple carjackings or multiple shootings or multiple gun offenses or multiple robberies. Does this come down to, Julia, the issue of why someone like Kim Fox or, insert prosecutor here isn't willing to charge people and just continue to let them out on the street?
Well, okay, so I'm not gonna. I don't want to second guess a fellow prosecutor's.
And I'm not asking you to bash somebody, but you
Right.
you have to make these charging decisions too, and you're charging things that Kim Fox isn't.
Well, I think from the perspective of this Safety Act and crime, what has been most frustrating for me and others of us is that a lot of the decisions that went into the creation of the Safety Act were based on issues coming out of a certain county. And what we've tried to do in our negotiations is to bring in the issues and concerns of other counties across the state. There are 102 counties in Illinois. Some of them, again, like I said, are one elected state's attorney and maybe a part-time secretary. But they have the same responsibilities and the same concerns as all of the rest of us do. I do think that there are ways that we as elected officials can resolve and address some of the issues in the criminal justice system based on the policies that we create within our own offices and within our own communities. And those issues do not need to be addressed by statewide legislation that upends the way everyone does business in their own communities. So there was just a study done that we sent around to everyone involved in these discussions out of Loyola University, looking at the decision making when it comes to charging, because all of us review and charge felonies in our offices. But in Cook County, here's an example. In Cook County, they what's called direct file all drug offenses. And that means that the police officers are the ones who are making the initial charging decision. And then the cases are going from there. And that process has implications through all the way down the rest of the system as far as what the end result is, being different from the way that it might be if a prosecutor looked at it, looking at it from our lens of our burden of proof and what we have to put in front of a jury. So those kinds of policy decisions within our offices can affect the bigger picture. And I would rather that we be the ones making those decisions than that group of legislators make policy for the entire state that doesn't necessarily address our concerns or issues.
What about from your perspective, Bob? I mean, you're obviously, right next to Cook County. You've had some issues where Cook County crimes have spilled over into DuPage County. Is this an issue with prosecutorial discretion, or is this a bigger issue?
Look, what I can tell you is that almost half of our felonies now are committed by people that don't live in DuPage County, many of whom are coming from Cook County and Chicago. We've seen a huge increase in violent crime by offenders coming from Chicago, some of whom are on probation or on parole. So it is a real problem. And while I value violence prevention programs and efforts, and actually have taken part in efforts through Fight Crime, Invest in Kids to prevent people from committing crimes in the first place, that can't be in lieu of prosecution and holding people accountable.
But is the lock them up and throw away the key mentality, maybe that anti-crime prerogative that kind of brewed in the 90s, does that still, did it ever work, I guess, is a bigger question, but is that working in this instance?
It can't be the only way to stop crime, but it is certainly a key part of it. You can't just arrest and prosecute your way out of the crime problem. Clearly, we need more investment in communities. We need better education, better programming. However, you can't have one without the other. You still have to hold people accountable, and you have to take violent criminals off the street. These crimes have a huge impact on the community, and people right now are genuinely afraid. I hear it all the time. People are afraid to go out. They're afraid to go to the shopping mall. We can't live like that. No,
a lot of suburbanites who don't want to go downtown.
Yeah. So both parts of the equation are very important.
And I'll let you guys go here in just a second.
That's what I put in the little chat. This both and. It's not a either or. It's not a either programs or lock them up. It's a both and. We've got to try to prevent things, but when we have these issues, we have to address them. And I want to throw into, Patrick, because you lived here and you know Champaign County. It's really easy in Champaign County, and I think in a lot of other places, to say, "Oh, it's the crime from Chicago coming down here." Bob can say that because you're right there. I always, when somebody says, "Oh, this is just Chicago problems coming to our community," because we have significant gun violence issues right here in Champaign County, that I don't use that as an excuse for the people, for what's going on here in my home. These are our young people. We have to address this, and not just pass it off on, "Oh, it's Cook County." There's an element of that in many ways, but crime, gun violence, the things we're all experiencing right now, it's not unique to Cook County. So it's a both and.
And Julia, since you have the prerogative of the entire group of 102 states attorneys in the state, dozens of your colleagues have filed a lawsuit, which has kind of been combined into one at this point, that is attempting to find the law unconstitutional. Tom DeVore kind of had the silly idea that it was the single issue law, which that's been passed by many times. But does the idea that multiple states attorneys, mostly Republicans, does that hurt your chances of trying to make the fixes that you're looking for?
Well, we've chosen to have basically a dual path here. I'm the president of the association. I mean myself, Bob, Jamie Mosser, Jody, who's from Peoria County, have been involved in the negotiations. And then there's another group of states attorneys who have chosen to file litigation and move forward. We're not competing. We're not adversarial amongst ourselves. Either way, however we can get this to the right place, we're going to be, we're working together in that respect. And certainly, if legislatively things do not go the way that we're hopeful they will go, Bob, myself, Jamie, Jody, we're all going to have to look at the situation and decide whether we join our colleagues in the litigation.
And Bob, final question for you is on that. I mean, how optimistic are you that there will be a legislative fix? I mean, you're, I again, as the other party, of the one who's in these conversations, you probably have a more critical eye than somebody who's on the same team. You
keep saying that, but I feel like you should know me better than that.
Well, I do know you better than that, but I mean, but there is a partisan affiliation, and there is a partisan part of this.
There is, but at the beginning, when I was first elected in 2004, I went to a States Attorneys Association conference, and I thought, oh my gosh, people are going to be, it's going to be awful. I just beat an incumbent Republican. I'm a Democrat. I'm a woman. I'm, new here. And everybody, said we're all colleagues. I really believe that Democrat, Republican, what's more important to the 102 of us is that we are all colleagues. We're states attorneys. We're prosecutors. That's what matters most to us. Maybe I'm idealistic in that sense, but I really don't see this as a political issue from my perspective.
Sure, but the legislature, and I think that's the direction that I'm going in for you, Bob, is what's your level of optimism here? And if there isn't a fix next week or in 2 weeks, what happens? What do you guys do then when we get to January 1st?
So the first part of the question is, I'm still cautiously optimistic that something is going to happen here, that there's going to be the improvements that we're looking for to make this law better. None of us are saying you have to bring back cash bail. We've accepted we're eliminating cash bail. We're okay with that as long as we have this strong preventive detention statute. I'm still hopeful that we're going to follow the New Jersey model. I think the legislators are well aware of what's happened in New York. New York's law, when they eliminated cash bail, really took the discretion of judges away. They had a 36% increase in crime over a 2-year period. New Jersey gave judges discretion. They did not see a real increase in crime. So that is the model. I'm still hopeful that it's going to happen. If there are no changes, we get to January 1st. Unfortunately, I think we're going to see a situation of chaos across the state because some counties are taking the position the law is prospective only. It applies to crimes committed on or after January 1st. Other counties are going to be doing detention hearings all through the month of December. And judges across the state are going to be interpreting provisions of this law differently, inconsistently. Unfortunately, we will see more violent criminals out on the street, and it's going to have an impact.
And Julie, I'll give you the last word here. I mean, that's one of the Republican complaints was that January 1st, we're going to have to open up county jail doors and let all these bad guys out on the street. And they referenced that silly horror movie, The Purge, in the campaign. In reality, be no hyperbole. And I know you're not that kind of person, and I appreciate that. But for those that don't know you that as well as I do, that what do we really expect if there's no fix by January 1st?
Confusion, and what Bob said. Some counties are going to look at things one way, others a different way. I know here in Champaign County, Judge Rosenbaum, we've been talking, and originally we were thinking we were going to do detention hearings the last couple of weeks of December. Now he's looking at it as, we can consider this prospective only. Maybe we'll do hearings later. But I know there are other counties that have already decided this is retrospective. And maybe that's a philosophical or political decision. Lake County, for example, I know he's made the decision that he's going to have hearings in December. And by he, I mean the state's attorney. And confusion, and that it shouldn't be that way. The state of Illinois, should be consistent across the state when it comes to these major policy issues. And I think that's a huge problem coming into this. And even, the Supreme Court has all these committees, and a lot of the advice that's coming out of the committees is meet with your judges and your public defenders and decide how you're going to do it. But that's not law. That's not the way to make change across the board in a state as large and diverse as Illinois.
Julie Rietz, the state's attorney in Champaign County, Bob Berlin, the state's attorney in DuPage County. Thank you both for great conversation, for kind of pushing aside some of the campaign rhetoric that we had from both sides. It's nice to get honest discussion about these things. So thank you so much for your time.
Thank you.
Thank you, Patrick.
That's Bob Berlin, the state's attorney from DuPage County, and Julia Rietz, the state's attorney from Champaign County, who are deeply involved in discussions of how to change the cash bail part of the Safety Act, the cash bail pretrial fairness part of the bill that has caused so much discussion and so much confusion over the last few weeks. So it's interesting to hear from them and get their perspective, and we'll see how things shake out over the next couple of weeks. As far as I know, there's no language agreed to in terms of what might get changed next week or in 2 weeks, and it doesn't sound like there's a lot of movement yet. So hopefully we'll get there. Hopefully we can. I've said from the start that judges just need the flexibility to be able to say, if you're a threat to the community, if you're a threat to a person, if you're a flight risk, if you're a bad dude, you should be held waiting trial. And I don't think it's out of line for both sides to get on board with that. But I'm just one guy, I guess. So thanks so much for taking time with us today on our live stream. And if you're listening to the podcast, we do appreciate it. Sign up for the newsletter at theillinoise.com. And we'll talk to you soon right here on our weekly The Illinoize podcast and live stream. Next week is Thanksgiving week. We may or may not be here on Wednesday the 23rd. So keep up on the newsletter. We'll fill you in then. Thanks so much and have a great week.